I'm delighted to welcome you all here for this event. As I was just sharing with Tibor, this is, for me, a delightful mix of faculty, staff, students, alums, and generally a very broad collection of folks who knew and loved Hal Berman. So I'm delighted to have all of you here. The events today are three events. It's really structured around a celebration of the scholarship of Harold Joseph Berman. The first is a presentation in normal faculty colloquium fashion by Tibor Varady. The second part will be roughly at 1 o'clock. We will shift and do a presentation of the new virtual library that has been created of Hal's works. And the third phase, at approximately 1:20, 1:25, everyone is invited down to the third floor to the Center for the Study of Law and Religion for the formal dedication of the Harold J. Berman Library and the glass of champagne for those that wish to start drinking. Have one with me at 1:20 on that.
Well, it's 5:30 somewhere.
It's 5:30 somewhere, yes. Me and Jimmy Buffett, I'll do it. It was almost 40 years ago that I was wandering around Cambridge, Massachusetts, trying to decide whether or not to enroll in the divinity school there or enroll in the law school. And I happened, at the recommendation of someone else, to go over and introduce myself to Hal Berman. And that, no doubt, changed my life. Because when I pushed Hal on whether I should go to divinity school or go to law school, Hal said without a doubt, you do both. I said, I'm not sure I want to do either, and he tells me to do both. But from that point forward, Ruth Berman was my mentor. Hal's wife, Ruth, welcomed me and my wife, Joan, to Cambridge, Massachusetts. Hal and Ruth got me through those 4 years, got us through those 4 years in Cambridge. I think it's in part because that was shortly after Susanna had just left the home and Hal and Ruth wanted another child in the house. And I became the fifth child of the family. I was honored. But obviously Hal not only got me through those years, but then has shaped my life and career ever since. It was my first priority after I came here in '82. Dr. Laney, then president, was able, and then Dean Tom Morgan, were able to get Hal Berman to come here in '85. And then, as most of you know, Hal Berman brought along his young student at the time, a fellow named John Whitty. So the first thing I want to do is express to you the regrets of my dear little brother John Whitty, who can't be with us today. This should be his event. In many ways, it is his event. But dear John is at a special function today at the Library of Congress, where he's a visiting scholar at the Library of Congress, and had an obligation that kept him there rather than here today. I'm going to turn it over to Tibor momentarily, but first I simply want to acknowledge that today we have, representing the family of Hal and Ruth Berman with us, Susanna Berman Omach, the youngest child of Hal and Ruth. Thank you, Susanna, for being here. And a bit of special information. We were also expecting the other daughter, Jean Berman, to be with us, but just last Friday, is that right? Friday morning, she helped her daughter deliver Hal and Ruth's newest great-grandchild, Noah Joseph Medina. So they now have 6, 7 great-grandchildren, I've lost count. But there's something powerfully symbolic that we welcome within this past week Noah Joseph into the world at the same time that Hal's birthday, if he were with us, would have been next week. So today's celebration really is a celebration of all that Hal has done, his life and his scholarship. There are few people more appropriate to talk about language and law and understand Hal Berman than Tibor Varady. Well, Hal Berman may have written 25 books and some 500 publications. Tibor was one, if I correct me here, was one of the first Fulbrights. Yes. Into the United States to study with Hal Berman, and has known and worked with Hal Berman, particularly on language and international law, longer than anybody. While Howe's works have been translated into some 15 languages throughout the world, Tibor's own works, 200, 300 publications, have been translated into at least 5 languages. Tibor, as you know, joined the faculty of Emory Law School roughly in '99, thereabouts.
As I started visiting in '88.
We had you here for a long time before that. We finally got you to join the faculty on a permanent basis
right.
In the late 1990s. But so Tibor is graciously agreed to offer for us not just taking some of Howe's unpublished works towards publication on language, but to offer us today his working draft of the introduction to that volume on law and language of Hal Berman. Please join me in welcoming Tibor for this colloquium.
Thank you. Thank you. Thank you. Well, thank you very much, and thank you for this really absolutely outstanding opportunity, and I'm most grateful for this opportunity. It is difficult to add something to what everybody knows about Harold, but let me pick just one thing. I think among many, many talents, Harold had an exceptional talent towards enthusiasm. He had a predisposition to enthusiasm, and enthusiasm helped him in being a most persuasive teacher and also a vibrant scholar. And one of the areas of his enthusiasm were exactly language. This has been a very important thing and a thrilling thing throughout his whole life. He knew, as the navigare necesses, that it's necessary to navigate between languages as well. And he also knew that it's not without danger to navigate. Now, he has a manuscript which has not been published and which I hope will be published. And this is Law and Language, Effective Symbols of a Community. And I would like to say something about this manuscript and add some of my thoughts. But maybe before that, let me also go back, as Frank did, to Harvard days, and to tell you about a little event, actually a quite embarrassing event for me. But since it was in 1967, the embarrassment has somewhat evaporated since. As Frank said, I had the luck of being the first East European student after World War II at Harvard with a Fulbright scholarship. And this really was a very, very important turning point in my life. And also this was an opportunity to meet Harold. And at that time, somehow, there was somewhat more interest in what I was saying than I deserved, because, you know, here's finally someone from behind the Iron Curtain, so it was interesting. And I was invited to many parties, and at one big party, somebody asked me about a professor of constitutional law. And I was really impressed by him. He was an outstanding personality. He was also a person about whom there was much more interest than information. So people really wanted to know something about him. And I was asked, what did I think about him? And I wanted to say that he was outstanding. However, my accent betrayed me. And I said that he was unique. And, well, that was really, really tough. And then Professor Baxter, professor of international law, and his wife came, and I don't know who of them asked, well, how do you know? And I felt something went wrong. I had no idea what went wrong. So I said, well, I am taking his classes, but that wasn't somehow evident. So there was a growing circle around me, and I was completely stunned and didn't know what happened. And thanks God, Harold Berman came to rescue. And he said, "What did you say?" And I said, "Well, I said that Professor Freund was eunuch." And he said, "You mean like in German, einmalig?" And I said, "Yes, yes." Well, he said, "What you said is not that. What you said is eunuch, which is in Russian evnuch." And I said, "God, that was really horrible." So, what I said was, not much more than a platitude had I really said what I wanted to say. And after Harold explained that I wanted unique and this little shift in emphasis was dramatic, so this was one of the many times when Harold really saved me, and I have enjoyed the blessing. And Harold, of course, immediately understood, since he was navigating between languages all his life, that what I should have meant, and of course what I did mean. But now returning to the book, Harold is perceiving the problem of languages. He does consider languages as a blessing, and he does consider languages as a problem. And let me say that during the past decades, and Harold was with us until not a long time ago, languages became probably even more important in a worldwide setting. You have the International Court of Justice, where you have two languages on an equal footing. You have several new criminal courts, like the International Tribunal for the former Yugoslavia and for Rwanda Criminal Tribunal. They have more than one official language, although the Tribunal for Yugoslavia is mostly proceeding in English. But practically every accused and every witness needs translation. You have the growing phenomenon of international commercial arbitration, where again English is taking more and more place. However, in a maybe majority of cases, there's some need to translate a document or something, a witness, and sometimes even party presentations in other languages. So the multitude of languages has become a critical fact, which is part of our reality. And actually, in his works about world law, Harold was facing this problem. And he was speaking about world law, and he was speaking about the need to consider diversity while shaping a world law. Let me just find a quotation of his, which is an important one. He has a short essay entitled World Law and the Holy Spirit, and there he states that in the 20th century, for the first time in the history of human race, most of the peoples of the world have been brought into more or less continual relations with each other. We speak without hesitation of world economy, world technology, worldwide communication, world science, world sports, and we are beginning to speak about world law. And then he says that it is very important to deal with diversity, and he speaks of a commitment, which commitment is inspired with the love thy neighbor principle. And he says such a commitment is necessary if the forces of world integration are to overcome the forces of disintegration, and disintegration should not take the place in the integration should not take place in the unholy spirit of Babel, but with full respect for the pluralism of its constituent elements. Harold is mentioning Babel here, and actually in his book, he is positing two metaphors. He captures the problem under the metaphor of Babel, and he captures the solution under the metaphor of Pentecost. And let me again cite Harold. Speaking of Babel, he said that story tells us that at one time all men spoke the same language, but because of their pride, God confused the languages of all earth, he's citing the Bible here, so that men could not understand one another's speech. And then comes the Pentecost, and again I'm citing Harold, which tells us that at a place where people of different languages had gathered to worship, certain of them were given the power to speak in other languages, so that all the people of the earth could hear the mighty words of God in his own native tongue. Now, having posited the two metaphors, let me try a little bit to go into the real life of multitude of languages. And this is what I try to devote my paper to, problems and instances, and how really can one and should one navigate between languages. And there's one question which is maybe a prior question, and that is languages are prompted, and translation is prompted by the need to understand. And this is the truth, but not the whole truth. Because sometimes translation is prompted by other needs. One of the interesting situations is the dissolution of the USSR. USSR was dissolved, and Russian is not anymore the official language in countries like Kazakhstan, Uzbekistan, Kyrgyzstan. There is a case I'm citing, the Finnmark case, where a motion to compel arbitration was started in the US. The Tajik government was served by process, and the service was first in English, which was clearly inadequate, and then in Russian. And Russian would have been adequate 5 years earlier, but not at this moment. Now, it's pretty unlikely that those judges who spoke Russian 5 years earlier have forgotten Russian. But it's also true that the Foreign Sovereign Immunity Act says that it has to be, service of process has to be effected in the official language of the country. And the official language of the country became Tajik. And we had recognition of foreign arbitral awards, where under Article 4 of the New York Convention, the award has to be submitted in the official language of the country where you seek recognition. And what if this language changes? You had again some ex-Soviet Republic cases. And in this case, it was held that, okay, they probably do speak Russian. However, this is what the law says. This is what the convention says. And of course, this was dictated much more by national pride than by a need for understanding. Then am I citing also some cases in which, in a US proceeding, the question was whether someone who spoke Creole, whether Creole should be translated into English, whether Creole is a language. And after analysis, the New York court found that Creole indeed is a language, and translation was needed. Probably they understood each other. And then when Milosevic was brought to trial to The Hague before the International Criminal Court, former Yugoslavia, then the prosecution wanted to send him all documents in English. Now, he did speak English. I don't know whether you know this little episode from the biography of Milosevic. He was for 5 years a banker in London. Probably not what he's really best known for. So he did speak English. But he said and stated that he is more at ease with Serbian, which was probably true, and he was seeking translation into Serbian. So sometimes the cause and the reason for translation is not primarily understanding, but rules, pride, an endeavor to assert identity. And this makes things even more complex and sometimes difficult. But let me also say that translation can, of course, go wrong. And, well, there are several reasons for that. One is, and Harold notices, studies this, that there's a difference between legal language and language of common people. And let me tell you that in most, at least arbitration cases I was aware of, translation was not done by lawyers for a very simple reason that interpreters and translators are getting between $30 and $50 per hour, and lawyers earn more than that. So it's difficult to find and hire a lawyer. It's easier to hire someone who is a linguist. And this is fine. Linguists are usually excellent and even better than lawyers. But will a linguist be able to really tell what's the difference between void and voidable? How would a linguist know what certiorari is? So here there is some built-in problem with the translation system. And I wanted to mention also one thing. Very often the problem is an interpretation of unclear provisions in a contract. Now, what is unclear in the original, if it is translated, would the same issue be reflected? Would the same chances emerge for translating in one direction or the other direction? So translation is something very, very difficult. It's wonderful at the same time. And there's one really odd example I'm mentioning here, again from the Tribunal for the Former Yugoslavia, where the problem was a mistranslation. And let me just mention this. There was a conversation between Radovan Karadzic, one of the villains of the Balkan conflict, and they were talking about someone called Berjanin, and Berjanin was later accused. And this was intercepted by the CIA and by some other international agencies. And then the transcript was presented to The Hague, and it became public and discussed. And in the transcript it was stated that Karadzic says, now since Berjanin was sent to Jovica, Jovica was the head of Serbian secret police, and he went fishing with Jovica, we got a hold on him. Now, it sounded a bit odd. Why would someone create a hold on Jovica after he goes fishing? And that was really a bit odd. And what happened was that frisch in Serbian and Croatian is riba, ing is nje. So when somebody said riba nje, it was translated to fishing. But riba nje actually means, in a figurative sense, giving someone a good dressing down. So he was sent to Jovica, and Jovica had some harsh words about him. Now, the problem is that what came before the court is that this man went fishing. And you have 13 pages of the transcript before a Judge Agius. And Judge Agius said that, well, it's so odd. I went so often fishing with friends, but I never got a hold on me before of that. So what could this be? And let me tell you that after 13 pages, somehow it started to transpire that it's fishing, that riba nje may not be fishing, but it is maybe scolding or slating or giving someone a good dressing down. You know, this is like if I would translate the giving someone a dressing down like assisting someone in striptease or something like that. So it is really not the same thing. Now, let me mention another problem in connection, which has become a problem, to which I devoted some articles, and this is the following problem. English has become the dominant language, particularly of international business, but not only of international business worldwide, and in international commercial arbitration, in many other areas, in contracting, English has been the dominant language. And it's quite often, it happens quite often that a party from Romania and a party from, let's say, Denmark draft their contract in English. Or a party from Hungary and a party from Germany draft their contract in English. Now, what the problem is here, that actually the original is in essence a translation. Because these are not native speakers, these people probably do not have, or sometimes do, but not always have, a perfect command of English. So the original is actually a translation. And what if the original has flaws? I have an ongoing arbitration case in which the problem is the following. There's a Bosnian party and a party from Norway. And I have a contract which had difficulties, and the Bosnian party wanted to suspend the contract. And suspension in Bosnian, Serbian, Croatian is all the same, is staviti u mirovanje, which means, translated, to put it to peace. So the Bosnian party wrote to the Norwegian, I said, I want to put the contract to peace in English. And the Norwegian party said, fine. And now the dispute is that the Norwegian party believes that the contract was terminated, and the Bosnian party believes that the contract was suspended. And how to come to truth here? Well, let me give you another example. In a case I had, there was a public procurement and a tender, which was a French tender, and there were people who were applying for the tender, and all documents had to be submitted in French. The winner was eventually an English party, an English company, and they also submitted their contract in French, but the French was sort of tainted by the original English, by a language which is behind the original. I call this anchor language. And one of the problems was the following, that in the arbitration agreement, it stated in French that their arbitration tribunal has no competence for dommage par conséquence, which means damage as a consequence. Now, the English obviously meant consequential damages, but they translated it to damage as a consequence. And of course, every damage is a consequence of something. Now, the question is, are we entitled, the decision makers, to go beyond the original and to seek the anchor? And this has become a quite important element of modern international contract interpretation. It is a little bit similar like going back to legislative history to establish what could have been meant. Can one go back beyond the French original, which says dommage par conséquence, which means damage as a consequence? And can one go back and say, since the English drafted it, they must have meant consequential damage? Or in a case, a Hungarian and the German party agreed on dispute settlement by the chosen court next to the Hungarian Chamber of Commerce. Now, it doesn't mean much, but in Hungarian, választott bíróság means chosen court literally, but it actually means arbitration. So they obviously meant arbitration, but since in Hungarian arbitration is chosen court, they said chosen court in English. Now, and it doesn't make really sense to say that the parties wanted a court which is in the vicinity of the Chamber of Commerce. So it makes much more sense to translate chosen court as arbitration, but for that you have to reach for the anchor. And can one go for the anchor? In this case, we all agreed including the English arbitrator, to go for the anchor. But this has become a quite challenging problem of contract interpretation, and it is not an easy predicament. Now, I would like to leave some time for discussion, so let me just veer towards ending this short presentation. Navigating between languages in everyday legal life has become a really challenging task, and a task which is emerging with an amazing frequency. And therefore, it does need attention. Now, I am trying to conclude this paper by some remarks about a person who is a patron saint of the translators. I didn't know before I was plunging into law and language issues that translators have a patron saint, but there is one, and this is Saint Jerome. Saint Jerome, who translated the Vulgata, the Bible. Now, he was born in Stridon, and I was trying to check where is Stridon. According to some data, it is in Italy, according to some data in Slovenia, according to some data in Croatia. So it's about there. Now, he also lived in Trier, Germany. Trier is incidentally also the place of birth of Karl Marx. But he lived in Constantinople, in Bethlehem, in Antioch, the desert of Chalcis, and many, many other places. So he translated the Holy Script from Hebrew, and, but he was also a brilliant intellectual, and if you read some of his letters about translating, it's so unbelievably modern, so unbelievably up to date that he's really really completely in line with what is happening nowadays in this field. And in one of his letters to Pamachius, and he has several letters, he's writing also about literary translation, and says it is difficult in following lines led down by others, not sometimes to diverge from them, and it is hard to preserve in a translation the charm of expressions which in other languages are most felicitous. Each particular word conveys a meaning of its own, and possibly I have no equivalent by which to render it, and I make a circuit to reach my goal, and sometimes I have to go many miles to cover a short distance. What is important about Saint Jerome, that his main emphasis is not just to strengthen the faith in the miracle of translation. He knows that the miracle of Pentecost is not easy to achieve, but he didn't try to offer encouragement by way of eliminating doubt. He tried instead to show and to point out various causes of problem, various sources of doubt, and thereby to enable translators to cope with them. And I think that the more we are aware of the inside structure, of the layers, of intricacies, of traps, the closer we can get to the spirit of Pentecost, and the closer we can get to Harold Berman as well. Thank you very much.
Thank you, Tibor. Thank you for working this unpublished manuscript and putting it in shape to be introduced to the world in the very near future. Keeping with our colloquium tradition, I do want to have time now for about 10 minutes of questions from anyone. Up to Tibor, 5 to 10 minutes max, before we go to the virtual library. Judge.
Thank you, Professor Varady. That was excellent.
Yeah.
And I'm very interested in having just come from the ICTR those 4 months. But when there are two official languages in a tribunal, which version of a judgment would control when there is a distinction in the meaning of the language used?
Okay, well, that's a difficult and not rare question. Uh, there is one, both are equally valid unless one is made authentic. And sometimes one is made authentic, sometimes one is not made authentic. If there's no authentic text, we have essentially the same problem which also emerges in regard to treaty interpretation. And there are quite a few cases in which an international treaty is equally authentic in 2, 3, 4, 5 languages. And although treaties are usually being worked out with a lot of endeavor to get it right, but sometimes there are some differences. Now, there's the Vienna Convention on Treaties. And this Vienna Convention offers a solution which is maybe easy to accept as a principle, but way less easy to implement. The Vienna Convention says that if you have conflicting formulations and conflicting possible interpretation, the interpretation which best reconciles the various authentic texts should be accepted. Now, how to get a reconciliation is not so easy. There is a case decided by the Permanent Court of International Justice, the Mavromatis case. David Berman certainly knows very well this case, in which there was again a problem between various languages. And then the court held that the lowest common denominator is what applies. So if one language means that much and the other language means a little bit more, then the lowest common denominator is the one which is reconciling. This was before the Vienna Convention. The Vienna Convention doesn't mention the lowest common denominator. It mentions what is best reconciling, also considering the aim of the treaty. It's difficult to criticize this solution, but it is not so easy to apply this solution. And this is all I can tell you. Sure. Yes?
Yes, sir. Go ahead.
Have you ever encountered problems, quoting Winston Churchill, the common language that divides us between English and American English?
Well, if you read a case which I am actually citing, it is again before the ICTY, where one party stated that he wants translation to Serbian rather than Croatian. And Serbian and Croatian were the same language until not very long ago, and they are the same language for all practical purposes. But he said he didn't understand because there's a geographical region called Zapadni Srem in Serbian and Zapadni Srijem in Croatian. Pretty unlikely to miss it. And then Judge Agius said that you have to be tolerant regarding such differences. And he said, sometimes also for us, it is difficult to understand a person speaking Irish English, French English, German English, American English, but we have to live with this in the spirit of tolerance and trying to understand each other. So this is the answer, yes.
Yeah, Tibor, in constitutional law and in many other areas of literature, there's a lot of exploration of the benefits of differences among different jurisdictions and learning because of the differences. And in your presentation, I think you mainly present the problem of different languages and translations as kind of all a problem. You know, sometimes amusing, but really a problem.
Yeah.
Are there any benefits to disparate languages and the kind of play in language that translation offers?
Benefits of the multitude of languages? Well, in the European Union, every language is official. And of course, It's a tremendous problem. And in practice, English is used most common, but French is also used and other languages are used. Now, what is the benefit of this multilingualism? I think without this, there would be no European Union. Because no country would really sacrifice its own language for the sake of unity. So, of course, it is much more rational to have one language. And there was one effort earlier with Latin to make it a worldwide language. But it was not diversity, but Latin what disappeared. So it obviously would be way more rational to have one language. But I don't think it is possible. So just as there would be no European Union, there would be probably no United Nations either, if only one language would be. So this is the rationality argument, which is I'm shifting one field of rationality where you are absolutely right to another field of rationality, which is also part of real life.
That's a perfect play, Tibor, off of going from the Tower of Babel to Pentecost and the metaphors that you have picked up from Hal Berman. I would love to be able to continue this conversation, but at this point what I want to do is shift to the second stage of our celebration. So join me one more time and thank you, Tibor.
Thank you. Thank you very much.